Good afternoon, all. Thank you for joining us for the Artificial Rights Symposium keynote address. I have to say, I thought that I would be less nervous to speak in front of a crowd since nobody's sitting in front of me, but still the same. My name is Paige Reese. I am the Senior Articles Editor for the Washburn Law Journal. It's my pleasure to introduce our keynote speaker for today, Kate Gaudry. Kate is a partner at the Washington, D.C. office of Kilpatrick, Townsend, and Stockton, LLP. Kate focuses her practice on helping clients secure patent protection, and most of her clients' innovations relate to AI or bioinformatics. She has authored over 60 publications relating to patent prosecution and examination, and she regularly presents at domestic and international conferences on AI and patents. Her work was pivotal in the shutting down of the USPTO's SAWS program, which secretly subjected select patent applications to increased examination scrutiny. Kate's research and data focus was recognized when she was one of 5 attorneys across all practice areas to be selected for Lex Machina's and Law 360's Data-Driven Lawyer Award in its inaugural year of 2018, and further when she was named a DC Trailblazer by the National Law Journal in its inaugural list. Kate holds a JD from Harvard Law, a PhD in computational neurobiology from UCSD, and a Bachelor of Science in Physics from Fort Hays State University. Welcome, Kate. Thank you for being here today.
Thank you, Paige. My pleasure. Let me share my slides. So I'm very excited to be talking to you all about machine inventions. This is a talk, it's a little bit different than what I normally give in that usually I'm sharing a bunch of data and talking about patent prosecution, maybe some strategies that might be used. And this is a much more forward-thinking talk that I'm excited about. And in that spirit of kind of unusual talks for me, I thought we would start with a question that's often posed in philosophy classes. So if a tree were to fall on an island where there were no humans, would there be any sound? And this question was first posed in 1883 by the Chautauquan, and they answered their own question. And they said, no, you need to have an ear in order to have sound, so there's no sound. And a very similar answer or question and answer was provided in the following year by Scientific American, who arrived at the same conclusion: no ears, no sound. And so I would say, now what if we take this question and we change it a little bit? What if we have a tree that falls and there is a nearby human? What was the cause of the sound? Was it the tree? Was it the human? Both? Who should get credit for it? And if there were some products that were generated based using the tree, like furniture, firewood, paper, who should own that? Would it be the human who heard it? Would it be the person who planted the tree? Would it be the person who owned the island? Right? And so now we can take all these questions that are often, like I said, somewhat philosophical, and we could ask similar questions to the topic at hand. So if we had an AI program that generated a new and non-obvious result, did it conceive of a patentable invention, right? If that result is sitting there in a computer somewhere, is that patentable? Now, if we bring a human into the picture, and so the human detects the result, and they say, aha, that seems like something we should file a patent application on. Who conceived of that invention? Was it the AI program, the human, both, or neither? Who should get credit for the invention, and who should own the invention? Now, patent offices around the world are considering questions such as these. For example, the US Patent Office about a year ago, they issued a request for comments, a request for information pertaining to AI and patents. It took them about a year, over a year, no, about a year, because I think that they had some time before all the submissions were due, to aggregate all those responses and to put them into a summary report, right? So they talked about what the shared conclusions were and where there were diverging opinions. The World Intellectual Property Office similarly had a list of different questions that they thought pertain to this intersection of AI and patents, and they've asked for comments, and they've also been hosting what they call conversations. And so these are very early in the morning for us, video calls that anybody can attend. They've had 3 on different issues, and then after each one, and then they kind of summarize these sentiments that have been conveyed by all of the stakeholders. The prominent conclusions so far of these types of discussions are that AI is a pretty diverse field. And so we need to be specific when we're talking about different topics about what type of AI we're talking about. And then the second conclusion is that with regard to many of the conversation points, The existing patent law is a pretty good starting space. For example, if we want to talk about what kind of written description, what kind of disclosure you need in order to support patent claims that pertain to AI, a good starting point is our existing disclosure laws. We might want to tweak them a little bit, but generally good starting point. And finally, AI tech is really important. And so these kinds of conversations are valuable, and we should continue to have them so that we can ensure that IP structures and IP systems are set up to provide protection that will really incentivize progress in these areas. Now, I'd like to make a few clarifications with regard to terminology. And so the first is, what is an AI innovation? Because you hear this a lot in these types of discussions and these kinds of conversations with the patent office. And generally, I think of it as having two different buckets. And so there are inventions that involve AI, like a new type of neural net, or perhaps a new workflow where you're doing some sort of filtering in your initial data, or some filtering afterwards, and you have a neural net in the middle. Or maybe you're using an AI result in a new way, right? So if you have a neural net that's like, there's a person, there's a stoplight, what are we going to do with our automated driving, right? And then there's a second bucket, which is new inventions that were discovered fully or in part based on a result generated by an AI. And that's what we're going to be talking about here. And so that result may pertain to AI, right? It might be a new kind of workflow, it might be a new type of model, or it might not. A second terminology clarification is the difference between inventors and owners. So in the US, the application, the patent application, is initially owned by the inventors. And then you can assign your right. And so you can say, here, company, you are going to own this instead of me. And a lot of times in employment contracts, there are provisions that say that the employees are obliged to do that. And so the owners are the ones that are controlling patent prosecution. Like, what is the claim scope going to be? What are we actually trying to protect? What kind of arguments are we going to make when we're trying to get this patent? And they're also controlling patent assertion. So are we going to sue somebody with this patent? This is a form that's frequently used. This is provided by the Patent Office to say, I'm an inventor. And so you need to file something like this. It's called a declaration or a substitute statement in the US. And I just want to flag this bottom statement here. So it says, if you make any false statement on this declaration, it's punishable by fine or imprisonment of not more than 5 years. So you need to be honest, right? You can't say I'm an inventor when you're not. That's punishable. It's not frequently interrogated, but nonetheless, that is a potential consequence. And then another terminology clarification that we've talked about a little bit in the morning session is the difference between narrow and general AI, or weak and strong AI. And so narrow AI or artificial narrow intelligence is focused on a particular task. You might be translating text from a first language to a second language. You might be trying to predict whether a picture of a mole is cancer, right? Artificial general intelligence is not focused on a particular task. It's supposed to really mimic the human mind. And a lot of computer scientists believe that one of the important things about artificial general intelligence is really, really good transfer learning. Because what that means is, and what we as humans do, is we take information that we learn in the first context, and we're pretty good about applying that in other contexts. So for example, at the beginning of this talk, I said, I don't normally give this kind of talk. My talks usually have a bunch of graphs in them, and they're rooted in data. But nonetheless, I'm using my experiences with all of those kinds of talks to inform how I'm giving this talk, right? Thinking about the feedback there that I had gotten, and that's going to be a data point in terms of how I made this talk. And as another example, you can think about when you were first driving, first sitting behind the wheel. You may have been drawing from experience like when you were in bumper cars when you were 5 years old, or when you were playing video games in an arcade or at home. Now the objectives there were very, very different. With bumper cars, you wanted to hit somebody. And with these video games, you often wanted to speed. And hopefully that's not your intention behind the wheel of a car, but nonetheless, it was teaching you something about how you were going to be driving this vehicle. Okay, for the purposes of this talk, we will suppose that a machine invention is one that's not trained to solve a particular problem, right? When we were talking about narrow versus general AI, it's going more towards the general side of things. And it has a filter to kind of detect something that's interesting, right? Maybe this is new, maybe this is something we might want to, act on or something of the sort. Is this artificial general intelligence? I don't know. Some people even hate the term artificial general intelligence, and they think it's not such a bright line distinction. It's more gray. And so if we do have artificial general intelligence, it would include these features, but it's not necessarily that a system, an algorithm that includes these features is artificial general intelligence. But this is what we'll talk about here, right? Kind of detects what's new and isn't solved for a particular, or isn't trained for a particular problem. Are we going to get there? You know, how has AI been advancing, and are we going to be getting this kind of power in AI? Well, things are moving along pretty rapidly now. And here's, you know, some headlines on that, and there's a bit of background. Neural nets were first discovered in the 1950s, and they were a lot of fun, and people were into them for a while, and then it kind of stalled. And the reason why they stalled is because computing power wasn't very good. And if you can't have computers that can process a tremendous amount of data, and then your neural nets aren't very good. So it stalled for a few decades, and it really picked up again around the 1990s. And you can see this. This is my one graph of the entire presentation. But you can see this in patent filings. So even though we're not talking about, you know, AI patents that are filed, it is informative to let you know how quickly the field is advancing. And you can see around 1990, the patent filings really started to kind of pick up. But then here's also a quote talking about the extensive investment that is occurring nowadays in AI startups. Okay, so I've mentioned before, patent offices care about what's going on in AI. And these are a couple of the questions that the US Patent Office identified when they were doing this request for comments. And so the first question pertains to inventorship. Should we allow non-human inventors? And the second one pertains to ownership, right? And so this is what to do in a situation where perhaps you have a non-human inventor, or should you let AI or a non-human entity be an owner, right? And so it's important, once again, difference between inventorship and ownership. So let's think about it. Going way back to the Constitution, what's the purpose of the patent system? Well, it's to promote the progress of science and the useful art. And the way that the patent system is set up to do this is a quid pro quo, where it's like, well, if you, inventor, give us the information about your invention and you work really hard to figure out that invention, and then we, society, will say it's all yours for a period of time, limited period of time. And one of the things you have to do in order to get that limited exclusivity is you have to tell us about it. Your patent has to be sufficiently detailed to enable one of skill in the art to make and use your invention. So when we think about who's getting what on both sides of it, for the patent owner, you get a lot of benefits because you protect your individual invention, and perhaps even more than that, because you're probably inventing a lot in the same space. And so you're developing, like, you have all these landmines, and you're kind of pushing out competitors from your space of interest. It's also an asset that you can use for a negotiation, or to attract investment, or maybe to encourage a potential acquisition. Now, for society, as we indicated, this can encourage individuals and companies to spend the time and effort to figure things out, to make inventions. And then also to actually push them all the way to market, because they have this exclusivity period where it might be more worth their time. And then finally, it promotes disclosure. And so it's not just promoting that like a trade secret environment where you have to feel like everything needs to be hidden in the server, you know, way back where nobody can find it, but it's actually promoting sharing this information so other people can build on your invention, and then also figure out how to make and use it once the exclusivity period is up. So what happens if, instead of having humans be the inventor, if we have AI algorithms that might be able to invent? How does this quid pro quo change? Well, the benefits to the patent owner, we'll talk about ownership here first, are pretty much the same, right? But assuming that it's a company or a human. The benefits to the society would be a little bit different. We're not necessarily promoting the brute force discovery that we were in the initial slide a couple of slides ago. Rather, we're going to be promoting like smart discovery through AI, and we're going to be promoting the development of really great AI models. For example, we're not going to be encouraging an inventor to test hundreds to thousands of different filaments to find one that works for the light bulb, we might be encouraging someone to build a model to figure out which one is most likely to work and save a bunch of time. So now if we transition from ownership to inventorship, what types of benefits does the inventorship requirement right now provide? Well, one, it might motivate the individual to invent. So in addition to having a contract with my employer, where my employer says, I'm going to pay you some money and part of your job is inventing, I might also really like seeing my name on a patent. And I will say engineers pretty frequently do put patents on their resume. It also informs society of who's contributing to this invention, which could be helpful when someone's deciding who to hire, who to consult, where to go with questions, anything like this, right? So that's the expert that you might go to in this with regard to this invention. There's the fairness argument, and it also adds clarity to the chain of title. And so one of the things that patent attorneys frequently need to do is to make sure the assignments are all in order, so that if company X says, I own this patent, that they actually do. So you start out and you say, okay, the inventors assigned it to company one assigned it to company two, and you go on and on and on, and make sure that there are no breaks in the chain. So identifying the inventors lets you know where to start. Now, if we have a machine that's contributing to the conception of the invention, do these justifications still make sense? Well, the motivation's out the window. You're not going to motivate an AI to invent just because you're putting its name down. But all of these other justifications would still apply. The US inventorship requirements is that each listed inventor must have contributed to the conception of at least one claim. They need not have been involved in the reduction to practice. So they do not need to be involved in the experiments or anything of the sort that indicates that it actually works. If that does not require inventive skill. So if I find a composition for a drug that I'm pretty sure based on my model is going to work to treat this disease, I could go tell a lab tech or a company somewhere else to go test it to make sure it actually does. I don't necessarily need to be involved in that. On the other hand, merely suggesting an idea of a target result without specifying means to get there is insufficient. So if I'm like, I have a great idea, let's cure Alzheimer's, right? Without any specifications about how we would go about doing that, I'm not an inventor on a patent. If somebody, in my company found it, that's the means of doing that. So here are a few hypotheticals that you can consider. I think we actually have time to go through them, that vary in the degree of how involved a person might be. So suppose that I'm using an off-the-shelf model and I'm saying, here's a set of small molecule drugs that are candidates for something. It's candidates for treating this disease. And I think a really great way of treating this disease is binding to this particular target, right? And so I say, model, figure out which one of these drugs is going to bind to this target with the highest affinity, and then we'll go file a patent application on that. Who's the inventor? Is it me? Is it the model? Or who contributed to the conception of that invention? Was it me, the model, or both? Well, in this situation, this is done pretty frequently. I'm defining the problem pretty well, and the machine is working in the manner that I'm expecting it to. So most people would say that the human's the inventor and the machine is not. Now we'll go down this list, and I'm going to provide less and less instructions to the machine. So here, instead of small molecule drugs, I'm going to say, find any large molecule biologic. Now the space of large molecule biologics, there's many, many, many more of them than there are small molecules, and I'm not defining which ones we're going to be looking at. So I'll say, find some large molecule biologic that will bind to this particular target with an affinity over the threshold. And so the machine very well may need to figure out how they're going to navigate this complex space, and I'm not going to be specifying that. So does that change things? Should I still be an inventor, or did the machine contribute to conception of the invention? And would it change if I say, I'm not even telling you the target, I'm just going to tell you the disease, and you figure out everything about how this disease works, figure out a target that's going to be a good one for the disease, and figure out how to navigate the large molecule biologic space? Or if I don't even say the disease, I just say, let's find any type of molecule that will bind to any type of target that's associated with a disease, right? And so you can see here how I'm providing less and less instruction to the machine. And so it's questionable by this last bullet point. I would contend I'm not an inventor anymore, but then who is? And so these are all hypotheticals, but as you may have heard in the morning panel, they're being pushed right now. So there's this team, Ryan Abbott is the lead attorney on the team, that has been applying for patent applications based on inventions that their team asserts were discovered by an artificial intelligence system. And in particular, they call this machine DABUS, the device for autonomous bootstrapping of unified sentience. And the neural network, or the machine learning algorithm that is being used here, is a set of different neural networks, and they're trained in particular, each one has a particular knowledge domain to which they were trained. And then they kind of bind together, they kind of get connected together through controlled chaos, and each one's like outputting kind of a word, so you can think of it that way. And so they form these chains that are thought of as potentially ideas. And so then the machine learning model also includes this novelty detector to say, have I seen that chain before? Or does it represent something that might actually be a new idea? And the patent filings that are at issue, one pertains to a food container that has flexible walls having fractal profiles. And the patent application says this is really good because the Tupperware is essentially Tupperware, right? They don't stick to each other anymore. So you don't need to have those little sheets in the containers or in the boxes when you buy them at the store and in your cabinets. It's just easier. And then the second patent filing is a warning light that's just like flashing, but it's flashing in this way that's supposed to really attract your attention. So right now, DABUS is the only inventor that's listed on these patent applications. They filed these applications around the world. So far, Europe, UK, and the US have looked at them and responded, I guess, with something of note. And all three of these patent offices have said, you can't do that. You can't only list the machine. You need to have a human. And the DABUS team says, that's crazy. If we should be able to only list the machine when they're the ones, when that is the thing that's responsible for the invention. And they identified a couple of reasons why they think that that's a good idea. They said that that approach will incentivize development of inventive machines, like really good machine learning models, and encourage innovation. And it will also reduce the chances that some person says, this is my invention, when it's not. And an additional consideration is that it may promote disclosure instead of trade secret, right? So if I'm a company and I have a machine learning model that figured out some great solution for, I don't know, storing information in the database or querying records or something of the sort, rather than engaging in this quid pro quo of disclosure for limited monopoly, if I can't get that, and then I'm kind of stuck with trying to keep it a secret for as long as I can. So what are the possible alternatives if we change the human inventorship requirement? Well, one is like what the DABUS team is promoting or arguing that should be allowed in this particular case. We could say that the AI algorithm can be listed as an inventor. We could change the definition of an inventor. And again, Ryan had kind of mentioned this earlier, where the UK court seems to be saying, if you were to have filed this and you listed a person or a company, they could be a deemed inventor. They could kind of be the ones that were responsible for DABUS, and that would be allowed under our system. Or you could not require a listing of inventors at all. And this is what's done in Israel. And we also have some analogies to the copyright system. And so a couple of additional benefits of that option, or yeah, an additional benefit of that option is that you might have reduced transaction costs in patent prosecution. I can attest to the fact that filing these declarations can be very frustrating. There can be inventors who disappear or get angry at the company and they don't want to sign it. And so it can be expensive to try to track that down. However, if you get rid of this, as I mentioned before, you need to do this chain of title so that you're sure that you know who actually owns a patent. And without listing inventors, and then that might be harder. So I'm just ending again with the questions that the US patent system had initially presented. And I would encourage everybody here to continue to think about them. Like I said, these are issues that are attracting a lot of attention now, and I would not be surprised if we see some changes in the inventorship requirement laws in at least a few jurisdictions over the next 5-10 years or so.
Thank you so much, Kate. That was really informative and very interesting. I'm going to open it up to questions. So if anybody has any questions, please raise your little virtual blue hand in the participant list, and I can wait and see if we have any. All right, Professor Judd, go ahead.
Thanks, Kate, so much. I appreciate the talk. And I'm curious, I'm going to start with a very specific question, and that is, what did you think of the recently released USPTO report that took so long to compile, as you mentioned? You know, I'll show my bias up front, which doesn't seem to say much. And so I'm curious as to your reaction to that, whether you where do we go from here when you have that sort of report coming out?
That's a good question. I haven't thought about it. I agree with you. And I thought it was an egregious amount of time that came out. I think, honestly, they need to do more of the conversation styles. Like, they did one, I think it was in January of, I can't remember if it was 2019 or maybe 2018, they had like one like very, and you need more of that, right? Where it's very interactive. And this like paper pushing thing, it's the difference to me. You know, I'm a patent prosecutor, I'm going to the patent office, and I could probably do 4 or 5 rounds with an examiner trying to work things out. Or you could interview, and you could just like get to the meat of it and try to come to a consensus, right? And I think you need more of that instead of just ships crossing in the night. On that point, perhaps interestingly, I responded to their request for information on all of the issues, including the one that we're talking about here. And at the time, my response to this first question is, I said, that's ridiculous. I said, we are so far away from artificial general intelligence. And if we do get artificial general intelligence, and then we have many, many bigger issues to worry about. And I was like, and since it's so far away, then this question is uninteresting. And it totally changed my mind on it, right? But it was because I've actually had like 2-way conversations with people, like including Ryan and others, right? And so I think that would be the much more productive route.
All right, and we have another question from Kathleen.
My question has to do with whether or not the patent offices are interested in any way, shape, or form with corresponding their decisions on the owner and the inventor to the liability questions that we face all the time. Because ultimately, we know that some of these things will end up causing damages or being accused of causing damages to somebody in some way, shape, or form. And so if in fact we believe that we can assign the artificial intelligence machine itself as the inventor, for example, or will we always keep a corresponding legal entity as the owner for purposes of liability?
Well, so right now the legal owner is not at all tied to liability, right? So I could own a patent, but that doesn't mean if I have a patent on autonomous driving, and then if I'm not the one that is selling the car that's using that, I'm not liable, even if I came up with the technique, right? It's on them to do. So I would imagine that they would very much not want to talk about liability for many reasons, but including that it would really shift the way that patents right now are evaluated, even with regard to people.
Thank you.
All right, we have time for one more question if anybody has anything, but if not, I'm watching to see if any virtual hands pop up. All right, well, thank you so much, Kate. This was truly a great presentation, and we can close down for this section, and then our second panel will start at 1:15. If individuals want to stay on the Zoom call, they sure can, and they can turn off their video and mute themselves. Again, thank you, Kate.
Yeah, my pleasure. Thanks so much, Paige.